While I'm doing this, I'd like to thank Adam. Adam immediately came to mind, also an IEEE member, by the way, because a number of us have been deliberating over this change in balance between patent law and trade secret law. So we thought it was very appropriate to have Adam make a presentation on trade secret law. Let me see here. This one. All right. This one right here. Oh, geez.
Yeah, it's awesome to be here, and very hard to follow Keith and David. So tough acts, and so I hope I will not disappoint. Or at least I will try not to. Well, I think has been made very much clear in the past couple hours that the American Invents Act has brought a ton of changes to the patent system, right? And there's lots of unanswered questions. What counts as prior art? What counts as a disclosure? What counts as a derivation? What counts as a covered business method? That wasn't one of the topics I think that's been raised, but that's one of the big questions that's out there. That was one of the changes in the AIA, among many, many, many others. Now, all of these questions raised for me a really interesting and fun quote. I love this quote. I use it a lot in my teaching and in my talks. It's from Justice Joseph Story. For many of you who know patent law, you'll know that Justice Story, along with Judge Learned Hand, are two of the judges that developed the majority of the rules in the patent system that we now have today. And he said in 1841 in a patent case, patents and copyrights approach nearer than any other class of cases belonging to forensic discussions to what may be called the metaphysics of the law, where the distinctions are, or at least may be, very subtle and refined, and sometimes almost evanescent. Right? Now, one of the reasons why he was saying this, the patent law is the metaphysics of the law. And to engineers, that's the fighting words, right? You're like, what? No, we need facts and we need objectivity. Is that in 1841 there were still lots of new issues that were developing in patent laws. Patent law was very much unsettled. There was no peripheral claiming yet. There was no doctrine of equivalence yet, as distinguished from direct infringement. There was no non-obviousness doctrine yet. It hadn't been yet identified and separated from the novelty analysis. And so, of course, we're all over the map on these issues. Now, very significantly and relevant to David's slide about the increase in cases after 1870 on public use and whatnot, there's another interesting correlation statistically. In patent litigation rate studies from 1790 to 1860, the average patent litigation rate was 1.65%. I mean, it fluctuated a lot over the various decades, but the average rate was 1.65%. The one decade that it skyrocketed, and I mean skyrocketed, the one decade in that period when it went to 3.6% patent litigation rate was the decade of 1840 to 1849. And what's significant about that was that that was the first decade after the adoption of the 1836 Patent Act. And the 1836 Patent Act, as many of you know who've studied patent law, know that was the Patent Act that created our modern patent system. And there were all of these new interesting questions, the same types of questions we have with the American Invents Act today. And in fact, coincidentally, the people who promoted the American Invents Act said this is the greatest change to the patent system since 1836, right? So let's take them at their word. And we know exactly what happened after 1836 when patent litigation rates soared, because there was a lot of uncertainty about what all these new terms and phrases in the statute meant. And I safely predict that we are going to see the exact same thing happening today, if not already. The people built into their litigation expectations and cost-benefit analysis this predicted uncertainty, as the information travels faster now than it did back then. So the AIA, in effect, brings back the metaphysics of the law to patent law. And I think, as David made very clear in his presentation, there's tons of uncertainty now in patent law. People are just realizing, I think, the degree of uncertainty that pervades the American Invents Act. Every section, every phrase, every aspect of it is going to ultimately have to be litigated and resolved either by the Federal Circuit or by the US Supreme Court. Now, one of the issues that has proven to be now an open question is the status of prior commercialization of an invention before one attempts to patent it. Right? And this is a topic that David talked about. That's the statutory bar analysis. And it was the PTO's position earlier this summer that the American Invents Act actually repealed the bar on prior commercialization of an invention as a bar to applying for a patent, established in the metallizing engineering decision by Judge Leonard Hand, and it actually goes even further back to the Pennick v. Dialogue decision by Justice Story in 1823. And also this interrelates with the prior user defense, because now if someone is using something as a trade secret, they can continue to use it after the patent has patent issues on it. They now have a safe harbor. And so on both of these issues now, as I think David made very clear, trade secrets law is now extremely important in a way that it wasn't pre-American Invents Act. And it's important at least in the short term, because for firms and clients who are looking to secure their intellectual property assets and are trying to figure out ways to monetize their IP portfolios and develop innovative commercialization. Oh, I'm sorry. I apologize. All right. So firms that are trying to monetize their IP portfolios and develop innovative commercial methods and techniques for creating new value in these new types of inventions and ideas, that there's now going to be greater certainty in trade secrecy, at least in the short term, with respect to the uncertainties in patent law. And actually, because of these safe harbors, people might want to remain in trade secrecy and not pursue the patent rights. Now, this is very important because a lot of people who have been working with patented innovation in the creative industries, they haven't thought much about trade secrets beyond just the need to keep an invention secret in the short term before they actually file for their patent application. And so there hasn't been a lot of thought in the past 10, 20 years about trade secrets law as a long-term doctrine to secure IP assets for businesses and other types of commercial firms. Now, trade secrets for many, many, many years was shunted off into the back end of a patent law course. So many, many moons ago, when I was a law student, I learned trade secrets over the course of 2 weeks, so about 2 or 3 classes at the very tail end of my patent law class, where they said, oh, by the way, there's this alternative doctrine. You might want to know a teeny bit about it. And then in the ensuing years, as patent law grew in scope and significance, the patent law casebooks grew, and they had to cut material out, and they said, well, we'll just cut out trade secrets. And so you will be hard-pressed to find a patent law course today that covers trade secrets. And in fact, I teach trade secrets here at George Mason only because we actually have a whole course, a single course dedicated, a one-semester course dedicated to trade secrets. In fact, I have a couple of my former students in the audience. And when I tell this to my patent law and IP colleagues at conferences and stuff that I go to every year, they express both surprise that we have this class and jealousy that I get to teach this class. Because they're like, yeah, I kind of remember it a little bit. And so most people who work in patent law, the extent to which they learned about trade secrets is maybe an IP survey course that they took, or if they're old enough, they had that couple of weeks coverage in their patent law class. So the purpose of my talk is to kind of remind us what trade secrecy law is. I'm going to give just kind of a brief overview of trade secrets law and note the important issues that we need to keep in mind for those of us who are interested in giving advice to clients as to how best to secure their IP assets, and therefore how best to provide mechanisms, both legal and institutional, for commercializing those assets. So this is just the basics. I can't, of course, repeat the entirety of my one-semester class. And I'm hoping also to provide some time at the end for Q&A. All right. So just a quick distinction. This is the slide that I added last night at 1 a.m. I thought I'd give just a quick overview of the differences between patent law and trade secrecy. So this is not in the slides that were put up for the CLE, but I will make sure that this is added after the conference if possible. All right. So just quick a point on some of the differences. All right. The sources of law. Patent law is rooted in the Constitution, Article 1, Section 8, Clause 8, and as a result of that, granted power to Congress to enact laws to secure inventions and discoveries to inventors. Congress has acted upon this starting in 1790 and has adopted federal statutes, and therefore it's been adjudicated by federal courts, and has long been, since then, a federal issue and has remained a federal issue. Trade secrecy law is not federal, it's state law. It developed actually started to develop in the 19th century. It was one of the last IP doctrines to come into existence. And initially it developed in state courts, the common law courts. And then in recent years, in the late 20th century, there have been adoption of statutes which have codified these state court judge decisions. And there actually was the promulgation of a Uniform Trade Secrecy Act. And now, as of this year, 46 states plus Washington, D.C. have adopted either the Uniform Trade Secrecy Act in its entirety or portions of it. But even for the states that have adopted the Uniform Trade Secrecy Act, they continue to look back to the original common law decisions to determine what is trade secrecy. So they're using this long history of common law to interpret and apply the statutory terms that are provided in the Uniform Trade Secrecy Act. And so what you see is trade secrecy is primarily provided in terms of its summary of its doctrines and its requirements in two types of treatises. They're called restatements. For those of you who are lawyers, you know those are kind of restatements of the law. So it's the restatements of torts and the restatement of unfair competition law is where you see a summary of all the decisions and the doctrines that relate to trade secrecy. By the way, Virginia has adopted the Uniform Trade Secrecy Act, and so very important here. All right, now the nature of the property right secured by the different legal regimes. All right, so pre-AIA. Pre-AIA, patent provided a very strong exclusive property right for a 20-year term. And so it was very strong. You could go and shut down other people who were practicing their invention. It didn't matter if they didn't copy it from you, if they independently discovered it. It didn't matter if they were using it as a trade secret. You could shut them down. They were violating your patent. It was very strong. So in the law, we would say there were very few safe harbors from someone accusing someone else for infringing their patent. The trade secret actually provided a very weak property right. There are lots of exemptions to it. There's lots of safe harbors from lawsuits that I'll talk about during this hour. But as an alternative, it runs in perpetuity. As long as you can meet the requirements of keeping it a trade secret, it can run forever and ever and ever, and I'll give some examples of that in a moment. So the trade-off here was very strong exclusive property right, but limited for 20 years. Very weak property right, but it runs forever. The AIA has changed its dynamic now. Patents are no longer as strong, and there's lots of uncertainty, which is why this is trade secrecy is rising in importance, because this has now become more like this, a weak property right with lots of exemptions from infringement and hard to get it and determine what it is. All right. So what is a trade secret? Well, there's lots of different definitions, which is characteristic of judge-made law, because all the different courts have a slightly different way of formulating what the legal right is. But this is a really good summary from the Restatement of Unfair Competition, Section 39. In substance, all of the different definitions, whether in the Uniform Trade Secrecy Act or the Restatement of Torts, meet these various components of this definition. So a trade secret is any information that can be used in the operation of a business or other enterprise, and that is sufficiently valuable and secret to afford an actual or potential economic advantage over others. Now, I underlined any information valuable and secret because those are kind of the core elements that constantly come up in the context of defining and securing and litigating over trade secrets. And so I'm going to break out this definition into those three components and talk about those in a little more detail. But it bears emphasizing that because trade secrecy is rooted in judge-made law, the common law, right, cases are very fact-dependent and context-specific. And so it's very hard to deduce from abstract definitions of the law like this an answer in any particular case. Every case in the trade secrecy context depends upon the nature of the information, the nature of the efforts to keep it secret, and the context in which those efforts occurred, and the nature of the defendant's actions who's being accused of misappropriation of that trade secret. And in fact, courts love to use kind of classic property rhetoric when talking about trade secrets. They often say that trade secrecy law secures the valuable labor that creates the commercial information, and just for the same reason that you can't deduce definitive doctrinal statements or definitive judicial decisions from what it means to secure valuable labor. There has a lot to go. Lot goes into the intermediate decision-making process between application and that statement of this principle. You need to know those particular facts in every case. In fact, they often use the kind of classic phrase, the trade secrecy law secures the fruits of valuable labor. This kind of classic natural rights term. So let's break out this definition though and try to get some sense of how the courts have secured trade secrets by applying the requirements of, you obviously can't see that blue, very bad laser pointer. All right, so any information. What does it mean, any information? What does it mean, valuable? And what does it mean, keeping it secret? All right, so the first, any information. Any information literally means, unlike patent law, any commercial information that comes up. Any value, the courts will say, that's valuable information, or any value that's been created by its owner and it's owned by a firm, can be secured as a trade secret if they meet the other requirements. So any information, a product, a process, even what's referred to as negative know-how. So as scientists know, right, a null result sometimes is just as important as a positive result in an experiment. Well, null result is important because it tells you something about the world. And so negative know-how, knowing what not to do, is valuable information. And firms very often keep that secret. And there are cases in which negative know-how has been misappropriated by a competitor, and they've been sued, and the owner of that negative know-how has shown that it's a trade secret and wins because they show there's valuable knowledge in their commercialization of their activities. So some classic examples. We all know trade secrets. We use them on a daily, monthly, yearly basis. Coke is kind of the classic example. Coke is this trade, the famous formula of Coke. It's a trade secret. But some of you may not know the KFC recipe, the secret herb, the recipe for its herbs and spices. That's a trade secret. And in fact, I knew that because when I was a teenager, I worked at a Kentucky Fried Chicken, and I had to make these chickens, make the chicken, and the little packets, had trade secrecy all over them. And so when I learned this, when I started studying trade secrecy law, I said, well, yeah, that's fascinating. But some people don't know that Thomas English muffins, the process that makes those nooks and crannies, is a trade secret. In fact, there was a very famous case from a couple years ago involving someone who, a former employee, tried to steal that trade secret, and they were able to successfully prevent him from taking it to a competitor, because that trade secret, the recipe for making the nooks and crannies, is worth $500 million. Unbelievable, right? But also, other examples that include that have been and can be covered by patents, like manufacturing processes for making a chipset. These are all from a lot of these are from cases that I took. Genetically modified agricultural crops have been protected as trade secrets in the past. So as people know that they usually protect these with patents, but now people might want to return back to trade secrecy. There's a very famous case from the 70s involving a genetically modified agricultural crop where the court, where it was protected as a trade secrecy because, as the court noted, the evidence that was submitted that the chance of independent discovery was 1 in a trillion. Now that's not true anymore because of our growth and our knowledge of how to engage in identifying genes and whatnot, which is why people shifted to patents. But maybe people will want to shift back to trade secrets. And of course, manufacturing processes for making chemicals. A very famous case. DuPont versus Christopher. DuPont had a trade secrecy on a process for making chemicals, and Christopher flew an airplane over in a factory they were making to try and took photographs of the internal parts of the factory. And DuPont sued, saying this was a misappropriation of the trade secret, and won. Now, the reason why it's any valuable information is because we don't want judges making decisions about what they think is important commercial information or not, right? And so this is why the restatements and the Uniform Trade Secrecy Act has applied and commentators constantly say, you know, it is literally any information. So because you know, we don't want judges saying, well, I don't, you know, this might be information, but it's not the type of information that might be secured. So when they say information, they do mean any information. You don't have the subject matter restraints that we have on patent law that have been very much in play in recent years. As probably people in the audience know, Federal Circuit's now reviewing whether software is going to be deemed to be patentable subject matter or not. You know, following Prometheus, it's an open question whether DNA is patentable subject matter or not. And so there's lots of questions now about what can count as patentable. You don't have those questions in trade secret. But there are limits imposed by the other aspects, the other elements of the definition. So sufficiently valuable. What counts as sufficiently valuable? Well, again, we do not want judges making decisions about what they think is sufficiently valuable or not, right? So I have my chicken leg up there, right, to say, you know, you want a judge saying, you know, I've tried Kentucky Fried Chicken, and really, you know, Popeyes is so much better, right? You know, that's not a valuable recipe. And in fact, they're both actually really bad. They give you cholesterol, heart attacks. This is a disaster, imposes costs on our healthcare system. This is not valuable. This is a social deadweight loss for us. We should not protect Kentucky Fried Chicken and its trade secrecy and its herbs and spices. We don't want judges doing that. And so they lack what we say in law, we lack the institutional competence to make those types of decisions about what is commercially valuable or not. And they're very susceptible to capture by lawyers and various interest groups like the plaintiffs' bars and whatnot. Again, the phrase that you constantly see is secure the fruits of labors, and that's a very open term about, well, you know, what might be the fruits of labors, productive labors, is different from person to person, context to context. But you do see in the courts a constant focus on certain objective tests under this phrase, securing fruits of labors, about what makes something valuable. And the objective test that you constantly see the courts looking to is, well, what's the market value of the trade secret as an indication of its value? So for instance, KFC is a very extremely valuable recipe. And then also ex ante investments. So sometimes you don't have direct evidence of market value, but you have substantial evidence that the owner of the trade secret invested hundreds of millions of dollars over the course of many, many years to create this information. And that's an indication that this is some value because firms in normal circumstances are rational, and they would not do that. They would not give hundreds of millions of dollars to the research and development department if that wasn't producing something of value for them that they could exploit in the market for the benefit of the firm and its firm shareholders. In fact, under corporate law, they would be in a lot of trouble if they just said, oh, well, who cares what the impact on this is the bottom line. Let's just let the R&D folks go wild and do whatever they want with the funds of our money. So examples are like, this is, for instance, why in the famous case involving the Thomas English muffins, it's a great example too, because it involved Bimbo Bakeries versus Hostess. So this is one of the reasons why this case is also somewhat popular, because what a great caption, right? The Bimbo Bakeries versus Hostess. So this is why they got the information on the value of the nooks and crannies into the record. The court knew this because they submitted this information because they wanted to show this is valuable information. $500 million. And if this guy runs off with this trade secret, we're in trouble. We lose $500 million of sales of Thomas English muffins. So, and then R&D expenditures, and then also time to develop. Right? So time is money, as businesses well know. So it's not just direct expenditures on R&D, but how long? And so a lot of cases involving protection of trade secrets, the courts talk about how the parties showed that it took 10 years to develop this product or this process. And that's really significant information. They would not invest that time but for the fact that it was valuable. These are some of the objective facts that are used as evidence and that you as a firm or as a lawyer want to get into the record if you have a concern that someone has misappropriated and run off with your trade secret. You need to establish this. This information also is very important. This type of information is very important because it also reveals whether the information is, and the phrase you see used in trade secrecy law is readily ascertainable. readily ascertainable? Is this information readily ascertainable? And what they mean by that is this information already in the public domain? Do people already know this information? Now, this is really important because sometimes a firm will call something a trade secret, and it's not a trade secret. Everyone knows it. And so the point here is calling it a trade secret internally doesn't make it a trade secret. And if it is publicly known throughout the industry, then we're not going to let you propertize and claim as your exclusive use information that everyone else is already using. And this is somewhat familiar to us as patent lawyers as well. The great case on this involved a restaurant owner who claimed trade secrecy in basic recipes for meatloaf, fried chicken, chicken soup, and other kind of classic American food recipes. Now, there was nothing special in these recipes, nothing. I mean, so it wasn't like the herbs and spices in Kentucky Fried Chicken. I mean, it really was just fried chicken. You know, bread the chicken, put it on the grill, it's done. And the court just said, no, you can't claim this as a trade secret, right? This is public domain knowledge. You know, you may think this was a trade secret, but you're wrong in that. And calling it a trade secret and acting internally like you think it's a trade secret doesn't convert public domain knowledge into trade secret knowledge. So in a sense, what this prohibition on propertizing public domain knowledge ends up resulting in is that the trade secret does have to be sufficiently novel such that it's not already known by the public. Lots of court discussions about this minimal novelty requirement. Because again, the point is same as in patent law. You can't take what's already known in the public domain and claim that and propertize that as your own. And there's a very famous case from the end of the 19th century where someone tried to claim a trade secret or a method for selling insurance, but it was publicly known because it was a method for selling insurance. And in those days, you went door to door. So every door of the hundreds and thousands of doors that this guy went to, he exposed this method. And so competitors knew it, the public knew it, and now later the company's saying, oh no, it's a trade secret. And the court said, no, I mean, you're trying to do a do-over. You're trying to, you don't get do-overs, just like in patent law and just in trade secrecy as well. But it's very important not to confuse this minimal sufficiently novel requirement with the patent law requirement for novelty. It's not the same bar. So, other people can be using it as a trade secret. Other people can be commercializing it as a trade secret. That won't prevent you from securing it yourself as a trade secret. It's not a strong bar like you have in patent law. And in fact, in the cases where this issue about the novelty of the trade secrecy comes up, courts go to great lengths to ensure that there's no confusion here. And they often say, unlike in patent law, where novelty is a very strong bar to getting a patent, it is not the same bar we have in trade secret. And this cuts back to any information, right? Any information that is sufficiently valuable, as long as it's not publicly known throughout the industry or the world. All right. Now, the last element of the definition, efforts to keep it secret. Now, the requirement here, as you see, is that trade secrets owner must engage in reasonable efforts to keep the information secret. Now, as law students and lawyers well know, the biggest fudge word in the law is reasonable, right? It's the word that's the 64,000. I'm sorry, I date myself. The $64 trillion question is always what counts as reasonable in torts and every other area of the law in which this is a requirement. So how does this play out? Well, again, the courts end up focusing on various objective facts that the parties get into the record to establish that they engaged in reasonable efforts to keep something secret. Now, because the issue is reasonableness, it's context sensitive, and it's very specific to the nature of, the information, the nature of the industry, the nature of the firm, the nature of the activities that were actually taken, et cetera, et cetera. So classic examples, though, that you see constantly come up as good examples are the use of non-disclosure agreements with employees and contractors and subcontractors. For instance, in the Thomas English Muffin case, we learned in that case that there's only 7 people in the entire company that knows the secret process for making the nooks and crannies. 7 people. And they were locked down. They were the executives with non-disclosure agreements and all sorts of prohibitions on their use of this information outside the firm. And so limited access by employees and the public. So requiring perhaps maybe special passes to get into the area of the factory where the information is. Not allowing every single employee in, not giving public tours where the trade secret information is. That's been proven to show that in past cases that is problematic. So limiting access both to employees and the public to the information. And so, like I said, putting up signs, where there's a trade secrecy here and things of that sort. And that was, again, materials identified, kind of cut off at the bottom there. Materials identified as secret, right? So stamping things confidential, trade secret, putting, other examples that you found is that the information is kept in under lock and key in a safe somewhere. In fact, there was just a great news story about how the original Coke formula was transported to the new museum in Atlanta for Coke, in a locked safe and under armed guard, and and the reason why they're making a big deal about this is precisely they're signaling, we are keeping this under wraps. We are engaging in the reasonable efforts necessary to keep this secret. But again, it's very, very context specific, right? So they're not going to require a small firm with 5 employees to spend $50 million on secrecy precaution methods for maintaining their trade secret, when that firm maybe perhaps only brings in a profit of $10 million, right? It's context specific. What is reasonable? And that's why reasonable here works very well for the trade secrecy owners. They ask, for this firm, how much is it reasonable for them to spend to keep this, a trade secret? So they compare it to the value of the trade secret. Also, they ask questions like, is there a context in this particular industry where industrial espionage happens or not? Because there's some context in which there is no industrial espionage. And so firms don't spend a lot of money or time trying to erect all of these barriers because they don't need to, because the information doesn't get out. And so it would be silly to impose upon those types of firms in those contexts the requirements from the software industry or the requirements from the biochemical and pharma industries and other industries where industrial espionage can occur and does occur, and they therefore spend millions of dollars trying to ensure that their information is kept secret. And so, but the very important point is to get this information in about the nature of the information, how it can be kept secret, the nature of the firm and what it does and what's reasonable for it in terms of expending these transaction costs vis-a-vis its bottom line, and then the nature of the industry and whether industrial espionage is a problem or not. Now, one reason why reasonable efforts to keep something secret is important is this is in part a signal that this is valuable. So the reasonable efforts to keep something secret ties back into also that the information is sufficiently valuable. It's a bit, in layman's terms, asking the firm to put its money where its mouth is, right? You think this is valuable? Well, show us, right? Anyone can say something's valuable, but what have you done to secure this value to yourself? But this also means that there is no trade secrecy protection for what trade secrecy law refers to as, quote, self-disclosing ideas, unquote. So this phrase, self-disclosing ideas. And the basic point here, it's very commonsensical. If you can't keep it a secret in the very nature of using the information, then you're not going to be able to protect it as a trade secret. And a good example of this is a case from the early 20th century involving a fashion designer who sued to try to keep, to prevent the disclosure of some fashion designs of their clothing. And the court observed in a somewhat exasperated tone that judges sometimes use, and you have to know judges to understand how they use this, that the moment that you start selling this new dress on Fifth Avenue in New York, it's not secret anymore what the fashion design is, right? So it's really impossible for us to say that this is secret because you can't keep it secret. There's no way. It's in the very nature of the information that you're claiming here, the fashion design, that it becomes public the moment you start selling it to the public. and in fact, this is what happened, is that the fashion designer started selling the dresses, and the defendant copied them. And so then the plaintiff went after them saying, hey, you can't do that. It's a trade secret. And the court was kind of scratching its head saying, no, you're not going to get trade secrecy protection here. Other examples include designs of products that are right on the surface of the product when it's sold on the shelf in the store, just similar to the dress, the design of the dress, right? It becomes immediately known to the public, right? And you can see this also ties right back into the requirement under the information is sufficiently valuable. Is it readily ascertainable? Well, this is not readily ascertainable. This is readily obvious to the public that it becomes immediately known. And so it may have been a trade secret up until the moment you started selling it, but once you start selling it to the public, it's gone. And it's issues like that, which is why some people have, as patent lawyers know, it's because of this issue of self-disclosing ideas that you have this choice between, the strategic choice between going with trade secrecy and going with patent law. One of the issues is this something that will become known. And if it becomes known, then your patent law is your best option because, yeah, you're going to have public disclosure with the patent document, but you would have public disclosure anyway with the use of the information, and at least you get that 20-year strong exclusive property protection. This whole dynamic of this comparison has been now thoroughly thrown up in the air and undermined with the adoption of the AIA. All right, so those are the elements and factors that go into securing something as a trade secret. Let's talk about how trade secrets play out in enforcement actions. And this is our final slide, and then we'll have some time for questions. So if someone is suing someone for violating a trade secret, the claim is misappropriation. Misappropriation. And misappropriation means simply wrongfully taken. Now, classic example that most people think of information that's wrongfully taken is the employee who breaches the non-disclosure agreement. And a lot of trade secrecy cases involve that. So the Thomas English Muffins case involved the executive who breached a non-disclosure agreement and taking this information to the competitor from Hostess to Bimbo Bakeries. But it's not limited to that. It also includes information that is simply wrongfully taken, like through improper industrial espionage. And that's the famous case of DuPont versus Christopher. Christopher just flew the airplane over the factory and took pictures of as they were building the factory, took pictures before they built the roof on the factory of the machinery in the factory. And that was held to be misappropriation because that was held to be wrongful taking of the information. So you do not have to have a contractual relationship. In legal terms for lawyers, you don't have to be in privity with someone to sue them for trade secret, for misappropriating a trade secret. This is very important. It's the important aspect of what we mean when we say we protect trade secrets as property rights. They're not contract rights. They're not torts, because those require actual one-on-one interactions between people. Property means you can go after a third party whom you've never had interactions with, you've never seen in your life, because they've done something improperly vis-a-vis you, right? They broke, the analogy here is that, the burglar who breaks into your home at night and steals your money, you may never have met this person, you may not know this person, you may never have seen them. You can still sue them for violating your property rights. You don't have to have had previous relationship with them. It's the same rule in trade secrecy. So the trade secrecy cases, you can sue the person who took the trade secret, and that often happens because you want to get an injunction against that person to stop them from disclosing it. That was the Bimbo Bakeries, the Thomas English Muffins case. They actually sued the former employee to get an injunction to stop him from working with the competitor, and they won in that case. They got the injunction. But more importantly, you can go after a third party, like the commercial firm who hired your former employee, with whom you have no relationship with. You can sue that competitor for misappropriation because they knew. Or more importantly, they should have known. They should have known that this employee that they just hired from a competitor, who 2 weeks after they start working at their competitor magically comes up with the secret information that their competitor has been using for years in the marketplace. That at that point, well, yeah, you didn't just figure that out on your own. You learned that information and you brought that to our firm. And basically, the basic idea here is if something smells rotten in the state of Denmark with respect to a firm's activities with respect to hiring former employees from competitors, then they are held accountable to that. Or in other terms, no ostrich defenses, right? You can't just say, oh, well, we didn't ask the employer didn't tell us that he took this information. We didn't ask any questions. Well, that's because you chose not to know, not because you didn't know under any reasonable standard. If you can prove misappropriation, you get classic property remedies. You can get an injunction. You can get damages. Although the injunctions are unlike the injunctions in patent law, you don't get perpetual injunctions in trade secrets. You only get temporary injunctions where the courts try to figure out at what point would this information have eventually been discovered independently or reverse engineered, which are the defenses. And so you only get the injunction for that time period if you get an injunction. But if you meet the statutory requirements, you have information that's identifiable, that is sufficiently valuable, and that you can show you've engaged in reasonable efforts to keep it secret, then technically the legal protection runs in perpetuity, just like a fee simple or an easement, as long as those requirements are met. And this is very important. Is that the owner of the trade secret in suing for misappropriation has an affirmative obligation to prove that their information is a trade secret. And so it's in their interest to get in all that information about R&D expenditures and the commercial value of the information, like the $500 million on the nooks and crannies. But the reason why they put that information in there is because they actually have an obligation to prove that the information is a trade secret. And this is the classic idea, because if you don't have a property right, you can't sue, right? Dismissal. And so you have to affirmatively prove that this is a trade secret. Now, the reason why you have an affirmative obligation is because unlike a patent document, which is an objective document, publicly known, that's issued by the patent office, so everyone can look to it and identify it. In a trade secrecy case, very oftentimes, no one knew what this information was or that it was even a trade secret necessarily before the lawsuit occurs. So this is all new to the judge, to the people usually hearing about the case. So you have to prove, as the owner of the trade secret, hey, there actually is a trade secret here. See here, for instance, who here knew that the Thomas English muffins, that was a trade secret? See, no hands. Well, one person. That's awesome. So now, the defense is also to trade secret independent discovery. So if a third party actually independently discovers the information through their own research and development, then the courts, this goes all the way back to the 19th century, they say, well, that's fruits of productive labor, so we can't deny them the rights to use that. And so you can't go after that person for using a trade secret because they haven't misappropriated it. They independently discovered it themselves through their own productive labor. Now, very important, if they choose to keep it as a trade secret, then you both have trade secrets. But if they choose to disclose it publicly, then you both lose it. So slightly different dynamics than you have in patent law. And then reverse engineering as well. This is a little somewhat of a hard issue to get at. But trade secrecy only secures the right to use information. It doesn't stop someone else from figuring it out. And courts historically said, well, because reverse engineering is like research and development, it's productive labor. There's a difference between reverse engineering something and simply copying something blindly. Because effort has to go into reverse engineering. And it typically involves scientists and time and energy as opposed to just someone literally with a Xerox copying machine or in the 19th century by hand, copying down the information and running off with it. And a classic example of reverse engineering is that I mentioned Coke, and that Coke's formula is a trade secret. It really isn't, right? The Coke formula was reverse engineered a long, long, long time ago. And the reason why we know that is because there's Pepsi and Tab and all the other sodas that taste very similar to Coke. Now you might say, well, why? Well, if they reverse engineered Coke, why do they taste different? Well, they taste different not because they didn't reverse engineer Coke, it's because it's called product differentiation in the marketplace. If if Coke exists and you want to have a competing product to take away Coke's market share, you're not going to do that by saying, we taste exactly like Coke, because then you've given the consumers of Coke no reason to switch. But if you say, we taste a little different, then yeah, now they have a reason to switch, and they might switch. So all of that fanfare that Coke engages in about keeping their information, the formula secret, technically it is possibly still secret, but I mean, under the terms of how they've chosen to keep it secret, but it's been reverse engineered. And so it's really not a trade secret in any way. And that's one of the reasons why, for instance, Coke hasn't and never did consider suing Pepsi or Tab or any other makers of these colas that have competed with it. All right. So in sum, just to sum up, in using trade secrecy to secure commercial profits from an IP portfolio now, especially kind of in our post-AIA world, you have to think about doing a lot of things that you didn't have to think about if you thought solely in terms of applying for patents and getting patent protection. Right? You have to think about meeting the ongoing legal requirements for having a trade secret. Right? So it's not just about ensuring that you have your R&D department under wraps, right, with appropriate non-disclosure agreements and non-compete agreements and other types of mechanisms. You have to have more information than that because if you're going to have ongoing efforts to keep it secret. You have to also think about whether and in what ways the information can be reverse engineered. And so you have to think maybe ideally about how to possibly prevent this from happening. So you have to think strategically and very innovatively about the use of non-disclosure agreements, maybe the technological equivalent of digital rights management, or using any other technical or legal means to trying to keep something secret on an ongoing basis. And then lastly, very importantly for the business people on the side of on the side of using trade secrets as commercial assets, you have to think about how long it'll be before a third party independently figures this out. Right? As I said, very important in trade secrecy cases, there's no perpetual injunctions. Injunctions will be defined only by the term of time that it would take for someone to figure this out independently. And so you need to figure this out to appropriately value your IP assets and to determine ultimately even if it makes sense or not to invest, to engage in all that upfront investment through venture capital and whatnot in figuring out how to monetize this value down the road. So thank you. And we have some time for questions if anyone has any.
Thank you, Adam. We've got a couple here, and I've got 3 or 4 online.
Just real quickly, you did cover reverse engineering. And could you comment a little bit more on that? My understanding was reverse engineering was fair, but I've also seen some other opinions that seem to conclude that sometimes it can be unfair. Is that basically when there's an NDA or something like that?
Well, right. So the important thing to realize here is that there's no single one fact, because every trade secrecy case is context specific, that makes something a trade secret, right? So they're not going to say at the end of the day, oh, well, the NDA is the reason why this is a trade secret. It's the whole context of the activities undertaken. So someone might engage in reverse engineering, for instance, but if they're under a non-disclosure agreement, right, then that vitiates the claim to reverse engineering, because there's another fact that's relevant for them that they had to respect. Now, one of the issues with non-disclosure agreements, and especially non-competes that apply post-employment, is that the courts have to make sure that they balance the ability of people to sell their product or their labor in the employment market with the right of companies to keep information that is valuable to their bottom line secret. Because you can effectively end up with the use of trade secrecy doctrine basically turning employees into serfs, right? You worked here for 20 years. You're not allowed to use anything that you learned, anything about that relates to this industry ever again. After you leave this firm. And by the way, we fire you now. And these are actual cases that going back 100 years, and court said, no, firms can't go that far. But it's very context specific, and in those cases, it gets into the question of, well, what is the nature of the specific information they're claiming as valuable trade secret versus what's the general skill set that would be acquired by anyone who has received training and has worked in this particular field. And so they say general information and skill sets you can't prevent from being disclosed. under non-disclosure and non-competes, but specific secret information you can. But that, again, very context specific and very hard to figure out. Yeah.
Next question.
Yes, again, on the reverse engineering and the fruits of labor, you indicated that if there was an independent discovery that you could use fruits of labor as a defense. I'm wondering with the first inventor to file coming in March 16th of 2013, what the incentive is to reverse engineer and file your patent application March 16th for Coke's recipe or for the method of making the nooks and crannies.
Right. Well, the problem with that would be derivation, right? Now, it'd only be a problem if then Coke says, all right, well, we want to now file for patent 2. And as long as, so there's no problem with derivation if Coke says, we don't want to file for a patent, right? Because the derivation is only, 2 people are filing for a patent, 1 could not have derived it from the other. But what Coke still gets is the trade secrecy, what Coke gets is the prior user defense right that's been expanded to cover all patentable subject matter information now. So unlike pre-AIA, right, if someone got the patent, then they could turn around and they could get an injunction against the trade secrecy owner. And that was one of the issues that went into the very difficult cost-benefit analysis of do we pursue a trade secret here or do we pursue patent protection here? Is that if we choose trade secret, then there's the possibility, we have to figure out what the possibility is someone else might figure this out on their own, and then we'll get and then we'll file for a patent on it. And then we'll get an injunction against us for the 20-year term of the patent to prevent us from using our trade secret. That whole calculus has been upended by the IEEE with the creation of the prior user right defense that covers any use of any information that someone files for a patent on now. They can continue to use that within that firm. And then, again, by the way, and that's another reason why trade secrecy has become much more important, because now it's a more viable option, right? Because you can continue using it. Yeah, you now have a competitor with maybe a patent who's also disclosed it publicly through the patent. So other people will copy it. But you can keep doing it if you want to.
Adam, lots of software publishers have been using click-wrap license so they can mass market to everybody in the world and still keep everything a trade secret. Mm-hmm. They have clauses in there that say, thou shalt not reverse engineer. And these things are spotty and enforceable. Maryland and Virginia passed a Uniform Computer Information Transaction Act, UCITA. Mm-hmm. And they have kind of an independent sui generis prohibition which allows for the enforceability of such click-wrap licenses. Mm-hmm. Have you seen this having an impact on reverse engineering of trade secrets?
You know, no, but I don't know of any studies that have been done, empirical studies that have been done, and that might only be because the UCITA statutes that when they're adopted as statutes, it's still a relatively new phenomenon, and so you have it in the economic models. There would be an endogeneity concern because you have some states that have done it, but not other states, and information that's being secured by trade secrecy protections is in all the different states. So it's very hard to figure out if that has had an impact or not. Because there's other economic factors that go into whether, even if you identify the fact, for instance, that software programmers are flocking to Maryland and to the states that have adopted the UCITA, that might be also because they're being provided tax breaks or some other aspect of the economic calculus that's affecting their decisions. So I don't know if that's had an impact yet, but I don't know if anyone knows at that point.
Thank you.
I'm curious, you were talking about the injunctions being for a limited period of time, mm-hmm. based on the courts determining how long it would take for someone to reverse engineer. Mm-hmm. That sounds kind of problematic. I was wondering how they determine that.
Well, that's why, I mean, this is a unique aspect of how injunctions are issued in trade secrecy cases. So in trade secrecy cases, they typically bifurcate the trial for the liability portion of the trial and the damages portion, or in the remedy portion of the trial. And if the plaintiff is acting for an injunction, one of the issues that then becomes debated and discussed, and they have to submit evidence for at the remedy side, is how long would it be before this information is discovered? Now, for some firms, like as I said, back in the 60s and 70s with genetically modified crops, where the court observed that there was a 1 in a trillion chance of this being independently discovered at that time, right? They effectively got a perpetual injunction at that. I mean, it wasn't literally perpetual because the law rule is you can't get a perpetual injunction in trade secrets. But they effectively got one because it was going to be a really, really, really long time before someone figured this out independently. But for some, for some cases that for instance, that I cover in my class, you see 90-day injunctions or 5-year injunctions. And it's heavily disputed, of course, because the trade secrecy owner is saying, oh, it took us 15 years to figure this out, and we had to invest $300 million in R&D and thousands of man hours to figure this out. And and the defendant says, yeah, but that's because you were the first to do it, right? Follow on, and you got first mover advantage for that, and follow on people can figure things out faster because you kind of gave us some indications of where to look once you started selling your products in the marketplace. So, it's very complex. And by the way, this tells you how much of a mess the AIA is. That as uncertain as trade secrecy is, with all of these complexities and it's context specific, that this is now being viewed as preferable over the patent system, right? That by itself, I think, is the best way to summarize how much of a disaster the AIA is, I think, for at least the next 10 to 15 years.
I have one last quick question here, Adam, and then we have, there were 2 consolidated questions online regarding new trade secret legislation in New Jersey, and whether you knew whether there was a statute of limitations, or if you were familiar and had any comments on that.
Yeah, New Jersey, I don't know the specific aspects of what New Jersey did recently, but I do know that what New Jersey did recently was adopted the Uniform Trade Secrecy Act. They were one of the last. So they were the 46th state to adopt the Uniform Trade Secrecy Act. But the problem is that it's the Uniform Trade Secrecy Act, which was promulgated by the American Law Institute. It's just a statement of, well, this is the law that we think you should have, and every state makes tweaks to it. Very few states have adopted it wholesale. For instance, Virginia, which adopted the Uniform Trade Secrecy Act, made tons of changes to it before they adopted it as the law. So I don't know what changes New Jersey made to the UTSA when they adopted it.
Back to injunctions.
Yes.
If there's a trial for misappropriation of a trade secret, presumably the trade secret itself would become public knowledge through the judicial process. It's no longer secret. So what's the basis for the injunction?
Oh, well, under trade secrecy cases, the information on the trade secrecy is, the phrase is it's submitted under seal to the court. And so the information is kept entirely secret. It's not disclosed to anyone outside of the lawyers and the judge as to what the trade secrecy information is. And in the opinions that are issued by the judge, the sections where they talk about the trade secret, if they talk about anything in particular about the trade secret, those opinions are actually blacked out. And so if you go onto Westlaw, the database, and look at some of these opinions, there's bracketed portions where it says this portion of the opinion was redacted because it contained the information on the trade secret. So the courts understand this and understood this problem from the very get-go. If you file a complaint, you're in court. Courts are public institutions. So how do you enforce your trade secrets? So they adopted special rules for ensuring that the trade secret information was not disclosed through the litigation.
Thank you, Adam. Much appreciated.
Thank you. Thank you. It was a lot of fun. If anyone has any follow-up questions, I'll be around for the rest of the day.